To introduce the faculty for our first panel discussion, the elements of persuasive advocacy and effective cross-examination for international arbitration. The faculty members are Mr. John Bong, member of the SIAC Court of Arbitration and head of International Arbitration at Bay, Kim and Lee, Mr. Darius Chang, associate professor of law for practice at Singapore Management University, an advocate and arbitrator at Fountain Court Chambers, Ms. Youn Kim, partner at Kim and Chang, Mr. Nicholas Lingard, partner at Freshfields, Bruckhaus, and Deringer, Ms. Joy Tan, joint head of the Commercial and Corporate Disputes Practice, the Corporate Governance and Compliance Practice, and the Financial Service Regulatory Practice at WongPartnership. Moderating this panel is Mr. Hiroyuki Tezuka, member of the SIAC Court of Arbitration, and partner at Nishimura and Asahi. A warm welcome for our moderator and panelists, please.
Thank you very much, Michelle. Good morning, or maybe good afternoon, or good, depending upon your location. My name is Hiroyuki Tezuka, and I'm very much honored to serve as a moderator for this panel on day one. Which is aimed on the advocacy and effective cross-examination in the eyes of the counsel. We have 1 hour, and let me briefly explain about the format of this panel. I'm going to ask one of the panel members to briefly make his or her presentation on the assigned topic, one each for the written and oral advocacy and the cross-examination, followed by a very brief comment by one of the other members of the panel. And the total time allocated to one issue is just 5 minutes. So I hope that the panelists can manage to make their presentation and comment as briefly as possible. So let me just start with the first issue for the written and oral advocacy. I will ask John Ban on his thoughts about key features of persuasive written advocacy. John, please.
Thank you, Hiroki. First of all, I'm very pleased to have the opportunity to speak at the SIAC Academy today. My opinion, there aren't too many forums in the world where young practitioners and aspiring lawyers can get the kind of training that the SIAC Academy provides every year. So congratulations to the SIAC. I'll be speaking about persuasive written advocacy, and we can speak about this topic all day. However, considering I have less than 5 minutes, I will briefly go through some tips that I think can be useful for young lawyers. When talking about written advocacy, one must always keep in mind that improving it is a lifelong process, not a qualifying test that you can pass and then move on. We're all continuously learning. I've been a lawyer for 24 years now, and I'm still learning and improving. That's the nature of this activity. Let me begin by saying that the point of writing that we do is not expression. It's not to demonstrate that we are the best writers. No, it has a fixed purpose. That is to persuade the tribunal toward a position that is beneficial to your client. Too often I find that young practitioners are more concerned with demonstrating how well they can write. Therefore, always keep remembering to keep the following basics in mind. Your challenge is to use an often lengthy and tedious written medium to persuade a tribunal composed of suspicious and experienced lawyers. Simply put, never forget what your purpose is, which is to convince the tribunal, what your medium is, lengthy memorial witness statements, who your audience is, suspicious and busy arbitrators. Let these basics inform your advocacy. Clarity is essential because your audience does not have the time or inclination to spend time admiring your art. They need to be persuaded, and they don't want to waste too much time. So while you keep these basics in mind, let me also give you a few things to think about. First, while it's important to find or discover your own writing style, it is perhaps really important to ensure that you do the basics right. Well, while you will, with time, find your own voice and a unique method that you employ, but there's no shame in looking at what others are doing and learn from them. In fact, it is an essential skill. I remember back in 1997 when I was a young lawyer, I just started BKL. Korea still had a 6-day work week, and I would come to the office on the weekends and go to the BKL public folder on my computer and systematically go through the submissions the firm had filed in other cases. That's to try and pick up the language I want to use and common mistakes I wanted to avoid. Over time, in the next 5 years or so, we went up against and worked with some of the leading law firms in arbitration. The Devoids, the Freshfields, the Shearmans. I looked at their submissions and observed their style, structure, phrases that I could draw from, and I could practice in language that was commonly used in persuasive written advocacy. I remain convinced that to improve your written advocacy, you should look at what those around are doing and learn from them. This is a part of your own self-development. Second, this is something that I've seen a lot of talented young lawyers do, and that I recommend all of you to avoid. Stop trying to get everything right in the first step. You're not going to write a masterpiece in the first draft, and that's okay. You're not expected to. Too many young lawyers miss deadlines as they just try to keep writing the big thing. You must pause, understand that good written advocacy is a collaborative process. Finally, building on that, I will briefly illustrate what I think is a useful method of planning a draft. It might be better to write your outline first, sit and figure out what you want to argue, what your headings are, your subheadings. Then write down what you believe are your best arguments in bullet point or non-prose form. Then you build your structure. Second, if it's solid, get the opinions of others. Are you missing something? Check and then proceed to write the prose then. Build your end product bit by bit, not in one go. To conclude, I would just like everyone starting out to remember that improving one's written advocacy is a lifelong project, and that we all must keep focusing on. But there are several simple, small things that we can do to ensure significant benefits. Thank you.
Thank you very much, John. And, does anyone volunteer to make a brief comment? You have 1 minute. How about Nicholas?
I didn't volunteer to Sensei, but I'm very happy to make a brief comment. And I agree with everything John just said, which I think is very insightful. I would make the very basic point, which is this: overwhelmingly, our product as advocates in arbitration is written advocacy. The bulk of the work we do is written advocacy, and the bulk of the decisions arbitrators make for or against us is based on our written advocacy. So although the hearing, cross-examination are ever so important, I think everything John said needs to be borne in mind in the context of this being the core of what we do is in fact writing. And the decisions made for or against us is in fact based on that writing in most cases. So let's not forget just how important John's messages are in that context.
Thank you very much for your helpful insight. And next, I'll ask Professor Darius Chang to talk about his thoughts on the top 5 things to avoid doing in international arbitration for virtual hearings.
Yeah, thank you very much, SIAC, for inviting me. With your indulgence, perhaps instead of giving 5 points, in the 5 minutes I have, let me give you my top 3 points, but illustrate them with examples and real-life anecdotes. The first point I would like to emphasize is to avoid the misuse of visual aids. avoid the misuse of visual aids. This may seem like an obvious point, but this is a real life case. I was due to make submissions before an exit tribunal virtually, and it was 8 a.m. in the US where my opposing counsel was, 1 p.m. in London where the tribunal was, and 8 p.m. in Singapore for myself. A couple of hours before the hearing, the opposing counsel circulated a huge PowerPoint slide deck. And you can imagine, right? I was there flipping frantically through the slide deck to see whether there was anything new. Now, at the hearing, my opposing counsel started reading out line by line, bullet point by bullet point from the deck. I may be biased, but I'm not yet persuaded that this is the most effective way of advocating your client's case. To my mind, I'm fully in support of leveraging technology to deploy and display visual aids. But my suggestion is not to list legal submissions bullet point by bullet point on the slide. What I would suggest is that you consider flashing, for example, a critical contractual clause, highlighting the relevant phrases or words, or a photograph of the site or the power plant or the object that is the subject matter of the dispute with arrows pointing to the specific area and issue. I think these visual aids will have more impact than a wall of text on a PowerPoint slide, which is made worse when the advocate is simply reading from the slides. For the next 2 tips, I'd like to address them together, and they are: avoid putting every single document to a witness, and do not expect the tribunal to be capable enough of retrieving all the relevant documents. Okay. Now, I'm sure many of you will have sat through physical hearings where during cross-examination, the advocate will refer a witness to a particular document, and the tribunal member and the witness will swivel around, pick up the relevant bundle, look at the cover page to ensure it's the correct volume, and click the fastener, turn to the relevant tab, and then locate the relevant page. And then you have the next question. The advocate will refer the witness to yet another document, and the whole process repeats itself. In my experience, I find this process quite jarring to the flow and the rhythm of cross-examination. And from a tribunal's perspective, it's quite difficult to retain the witness's responses when every other minute you are performing a physical activity of hauling binders around. So in the pre-COVID world, in a physical hearing without the bells and whistles of fancy technology, my own practice has been to be really selective about documents to put to the witness. And insofar as there are key documents, I will put together in advance a cross-examination bundle so that all the documents that you want to refer to are consolidated in a single place. Now, with the online hearing platforms now, where we rely primarily on electronic bundles, I would still caution against putting every single document to the witness, because in my experience, having to maneuver between different PDF bundles is still disruptive to the flow of questioning. And indeed, we've all experienced our laptops or computers seizing up in protest when trying to scroll through a huge PDF file. So consequently, a soft copy cross-ex bundle is still something I would continue to recommend in a virtual hearing, but of course that requires advanced preparation. The last point I want to make is, rather than relying on the tribunal to locate the relevant document in your electronic bundle, it has become, with the help of technology, far easier for the advocate to share his or her screen, right? And indeed, that is something that is almost taken as a matter of course, taken for granted. And something that I quite like to do is to have 2 documents open side by side so that one can see the difference or the evolution, for example, the difference between 2 drafts of a contract. I'm mindful of my time. I'm going to stop here and pass the time back over to the moderator.
Thank you very much, and you're punctual. Anyone for any comments? How about Ms. Joy Tan? You have any comments briefly? Oh, turn on the microphone, please.
Yes, again, like Nicholas, I didn't volunteer.
Thank you.
I'm happy to be volunteer. And you know, I mean, I agree with everything that Darius has said. I mean, I think that there is the overlay of the virtual hearing on top of the sort of oral hearing advocacy that we know. And just to sort of add on to a couple of Darius's points, the top 3 points I had in terms of virtual hearing and virtual advocacy and virtual hearing is, I guess, firstly, go slowly because you know, with the technical difficulties, etc., very often you have the glitches, and you want to make sure that the tribunal hears you and the witness obviously later hears you. Secondly, take more breaks. Apparently, you know, there's been studies on how our attention span in the virtual context is a lot shorter than in person. And thirdly, I mean, the point that Darius makes in respect of documents, right? I think in a virtual hearing, we have the opportunity to deploy documents even faster than in an in-person hearing. You know, if you just sort of press a button and you share screen, right? You don't get that concern about the tribunal having to sort of turn around and pull out the binder and physically sort of flip through the pages very laboriously. But of course, that does mean that you have to be prepared. So either you have to have your team be able to locate the document very quickly, or you would obviously be able to have to be able to know how to locate the document very quickly. Or, you know, if you did have like a technical assistant from one of the service providers, you know, helping you, you need to prep them that you're going to refer to this document or the series of documents, possibly in your cross-examination bundle that you prepared beforehand.
Thank you.
So those are my tips.
Yeah, thank you. And next, turn to Ms. Sayoung Kim to talk about the case theory in relation to advocacy, please.
Thank you, Hiroyuki. Good morning, everyone. I'm glad to see you here, albeit virtually and cannot see your faces. But still, I would like to talk about the importance of a case theory and hope in the end you will remember what I tell you. To present your case effectively, the advocate must know how to tell a story to the tribunal. The story is your case theory. The reason you need a story is simple. For the audience, which is the tribunal in our case, it is easier to follow, easier to agree to, and easier to remember. A story then must have a theory and a theme. Let's start with an easier one. A theme is a word, a phrase, or a simple sentence that captures the controlling theory or emotion of your case. A theme is something that will help the audience to organize the information they receive and make decisions based on that information. So if you can have a theme besides your case story, you will be able to provide guidance to the tribunal to understand and agree to your case. The theme is more important in jury trials or criminal cases, but can also be effective in an international arbitration if there is a suitable one. So don't try to find it if there isn't a suitable one. I had a case on dispute among shareholders of a joint venture company where our client sought termination of the joint venture agreement. And the theme we had for that case was caught in the middle. The theory of the case, on the other hand, is something longer. That should include relevant law, which is the legal theory, facts of the case, which is a factual theory, and common sense. Why common sense? It has to be consistent with common sense because then, only then, everyone will be persuaded by this and it will be easier for everyone, including the tribunal, to agree to your theory. Your case theory controls your case. This has to be thus developed very early and becomes the blueprint of your case. They run through written pleadings, oral opening, witness examination, and oral or written closing. Even your theory has to be simple. Maybe there are 3 or 4 sentence summary of your real case. If I go back to my example in the joint venture dispute, our theory was something like, claimants and respondent became parties to a joint venture agreement when claimants and other heirs inherited their shares. Claimants and other heirs cannot agree on anything and cannot run the company together. The parties now need a divorce. Then how do you develop such a theory? The first thing to do is, of course, learn as much as possible about your case, objectively analyze the facts and evidence of the case, conduct legal analysis too, get a grip on what are strong points and what are weak points, then brainstorm and come up with a theory that will be solid and easy to understand. There are thousands of ways of doing this, so I won't say there's a right way or wrong way, but I'll give you a very important tip. It's the rule of three. Rule of three means that 3 items are more easily accepted than less or more. You heard Darius and Joy give 3 points. I'm not sure whether it was intentional, but we see 3 examples. I'll give you 3 examples. 3 little pigs, 3 musketeers, and one that we always use. I promise to tell the truth, the whole truth, and nothing but the truth. The rule of 3 is very often used by experienced advocates. Try to come up with the 3 sentences that will describe your case. Let me go back to my example again. Claimants and respondent became parties to a joint venture agreement when claimants and other heirs inherited their shares. Claimants and other heirs cannot agree on anything and cannot run the company together. The parties now need a divorce. Thank you.
Thank you very much. Any volunteer? Maybe Darius, please. Yeah, briefly, please. Yeah.
Sure, very brief. I want to emphasize what Say's book mentioned, which is about the emotions, because very often we deal with commercial cases where the dispute is about whether one party has breached a contractual obligations. And my young colleagues will be scratching their heads as to what case theory can we come about. It's such a simple, straightforward contractual dispute. But I like to emphasize the emotions, the motives. And in crafting the case theory, we would want to explore why did the opposing party breach the contract? What was the motivation? What was the commercial deal? Were there any other surrounding circumstances that would show that the opposing party had some incentive to breach the contract? So these are the color surrounding the larger dispute. That's all from me.
Thank you very much. And next, it's a big topic, but for a very short time assigned for Nicholas Lingard on the in-person versus online in written and oral advocacy.
Well, thank you. It is a big topic with a very short time. And I think several key points have already been covered. So what I want to do is say a word about what's the same with online advocacy, a word about what's different, and therefore some practical tips that I hope emerge from that. So what's same? The foundations are the same. Our objectives are the same. Our role as advocates is to persuade the tribunal to see the case our way, or more importantly, our client's way. We're still compelled to build a narrative or counter a narrative put against us. As Youn says, it's often about storytelling or countering the story that's been put to us. And that's the same whether we're doing it through a camera or in person in a physical setting. What else is the same? It may be that this is the longest time we have in front of our arbitrators over the course of the case, very likely is. And it may be, given how busy our arbitrators are, it's the longest single period of time they spend considering the case. So you have to use it wisely. All of that is true in person and virtually. But what's different? Well, the time zone challenge is a real one in the context of virtual hearings. You may well be deploying all the skills you've heard about from my fellow panelists very early in the morning or very late at night because your arbitrators, opposing counsel parties are scattered around the world. That's different. It's a different social experience. It can be quite lonely to be a virtual advocate. Depending on how your team is structured, they may well be scattered around the world also. And so there's a social dynamic that I think also bears thinking about. Of course, the technology is important. We're wholly reliant on the Zoom platform or whatever other platform we might use. So those general remarks, what emerges, some tips in the online context. let me offer these for consideration. First, I think polite skepticism is critically important. It's critically important in a physical hearing, but even more so in the virtual context. What do I mean by that? You want to be politely skeptical around the environment in which the witness is testifying virtually. Is she surrounded by somebody inappropriately coaching her? Is she surrounded by documents inappropriately available to her in the course of the cross-examination? Now, in a typical physical hearing, those issues don't arise because you see precisely by what the witness is surrounded. And indeed, in the sort of typical video conference cross-examination to which Gary referred in his opening remarks, those issues typically don't arise because you would typically have a member of your team travel to wherever the witness is and sit with the witness while she gives testimony by video conference. That's very hard in the current environment. What do you do about that? It may be you very politely begin your cross-examination by inviting the witness to move the camera around the room so you can inspect her surrounds. You need to do that ever so politely, but I think it's an example of this sort of polite skepticism. Next, and this has been referred to already, but I think it's extremely important, is to be very conscious of speed. If slow is good in a physical hearing, it is more than good in a virtual hearing. It is utterly necessary. Proceed at a gradual pace so the witness is with you and your arbitrators are with you. Next, and relatedly, and in some ways it's the same point, you need to know the documents ever so well. Sometimes in a physical hearing, you can see if the witness is in the right place. Perhaps you can't quite read the document on the table in front of him, but you know what the page looks like. You know he's more or less looking at the paragraph above the table on page 88 of the document you've put to him. That's impossible virtually. You really need to know the documents and proceed slowly so that you can identify the spot in the document that you want him to look at, and equally importantly, that you want the tribunal to be looking at. The final thing I would say is I would therefore encourage, and I think it's effective, to be asking the occasional question of arbitrators more in the virtual context than in a physical cross-examination. What do I mean by that? Virtually turning to the tribunal and simply saying, members of the tribunal, are you with me at paragraph X of document Y, to invite their affirmative confirmation that they are with you. You can do that silently in the physical context. They have the binder open in front of you. You've heard the cracking of the spine of the binder. That goes away in the virtual context. Little point asking the question about the arbitrators don't have it. I'd encourage you simply to ask, are you with me? Do you have paragraph X in front of you? With that, I will stop. I know there will be a great deal more useful tips that come up. Thank you very much.
Thank you very much.
I guess it's my turn to make a comment.
Please, please.
I was going to
briefly.
I have a feeling that I was going to be asked to comment anyway, even if I didn't raise my hand. But I completely agree with Nicholas, especially with his skepticism comment. To be honest, if you look at, if you attended the SIAC Congress last week, you heard for 15 minutes why I think a virtual hearing is not as effective as an in-person hearing. And the one thing that is different, and as two of the panelists alluded to, is examination. I mean, you cannot do a normal forensic document by document, cross-examination for 2 hours that you can do in person. You can't, the technology is good. You can look and the documents pop up, but you don't have the rhythm or momentum of using a series of documents to impeach a witness' credibility. And that is something that you need to learn how to do through virtual hearing. And this is something that, I think the lawyers in practice in arbitration are trying to adapt to. I don't have an answer, but that's something that all of us need to really adapt to with this virtual hearing, these days.
Thank you very much. Now I turn to Ms. Joy Tan on a topic which I believe many of the younger practitioners participant for this academy will be interested in. That is, how should younger practitioners build up a strong foundation in oral advocacy to eventually take on the role as lead counsel in international arbitration proceedings? Chang, please.
Thanks, Hiroyuki and the SIAC. It's always such a privilege to be here. So many lawyers, especially those from the larger firms, have a perennial concern about having insufficient opportunity for oral advocacy. I mean, most of our disputes, particularly the international disputes that we have, international arbitration, they tend to be sort of large dollar value disputes where the stakes are high. The clients are, reluctant to entrust the oral hearing to the more junior members of the team. So, the younger practitioners are challenged, I think, in getting the opportunity to build their skills in oral advocacy. So how do younger practitioners do that? And I think that all my panelists will agree that there's actually no substitute for actual practice, right? So, there's nothing that beats getting, the miles on the road, if you will pardon the expression. I think for those younger practitioners who are practicing in firms that have domestic litigation practices, they might be able to seek out some of these smaller cases where clients might be more willing to let the associate do the advocacy. In Singapore, there are also quite a few opportunities for volunteering for pro bono work, for instance, at our criminal legal aid scheme here. And that will give some of the younger counsel, the chance to get their feet wet and try the case in our domestic courts, right? But even in international arbitrations, I mean, there are sort of the disputes that might be on the lower end of the cost spectrum, where the clients are willing to let the juniors, have a go. And, there are those opportunities for the second chair, the third chair, to, conduct the cross-examination, right? Possibly for the witnesses that are not so the crucial witnesses for the case. It used to be frowned on, particularly when I was a younger practitioner, that you'd sort of split the cross-examination load, right? But I do think it's certainly now a lot more commonplace, particularly before international arbitration tribunals, that you would have, the second chair and the third, and even the third chair do some of the cross. In terms of upgrading your skills, there is nothing quite like watching, experts do it in person and learning from that sort of, hands-on experience in that sense. I mean, there are also mooting competitions that are open to practitioners, like, the Essex Court Chambers SAL moot. And of course, there's specialized arbitration advocacy training, like we are doing, this particular program, ably run by the SIAC today. So if you are a young advocate hoping to get more airtime, I have 5 notes for you. Sorry, Youn, I expanded from 3. First is, as I was mentioning, try to watch as much lead counsel in action as you can, not just on your own side, but take notes on that process. Especially if you're up against, Bae Kim and Lee, Kim and Chang, Freshfields, etc. Try and learn from the best. Ask your partners to let you take on some of the advocacy opportunities in the case, for instance, arguing the procedural hearing or trying to cross some of the more minor witnesses. Third, you should be looking out to try your own smaller cases and including in the pro bono space, or in the domestic courts if your firm does practice in that area. And fourth, you should be looking to upgrade your skills via these specialist workshops. Let me add 5 to that. And this is sort of general advice on your career, not just pertaining to your career in oral advocacy. I always tell people that it's good to build up a sort of core group of career mentors, as well as peers, whom you trust, and who can give you sort of advice and feedback on your professional skills going forward. So those are my 5 tips.
Thank you very much. Youn, you have anything to add? Yes.
Yeah. I knew it was my turn. So my 3 points, practice, practice, practice. And one sort of comment, I think, which others will not think of as something that's related to advocacy, is actually advocacy is all about delivery. And improving your delivery skill set does not have to be during the hearing. You can have opportunities for speaking slots like this, or if you can explain your case before your partners about how this should be moving forward, or you can have meetings with clients where you have to persuade them on a certain issue. Those are all grounds where you can practice your delivery skill set, and at the end of the day, that will help you or improve your advocacy later on. Thank you.
Thank you very much. I always tell my junior people to think about the possibility that your partner may get sick on the date of the hearing. So we need to have some backup plan. So I think it's very important to get ready for the young people. Okay, now I move on to the second part of our session. It's on the cross-examination. And let me start again with John for his thoughts on the preparation of effective cross-examination, which I believe is a very important subject. John, please.
Thank you, Hiroki. Like there's no magic bullet that will suddenly make you an incredible advocate. There's no one trick to becoming an excellent cross-examiner. These skills are developed over time, but fundamentally, there's one factor that is essential for a good cross-examination, and that's preparation, and then more preparation. Knowing your case inside out is not an empty phrase. It is reflective of a standard when no argument, no document, or no part of any witness testimony is not entirely known to you. Achieving that standard is the bedrock on which good advocacy is built. There's no shortcuts to this. Let me quote an excerpt from the GAR Guide to Advocacy. First, as has been noted by others, the single most important components of preparation are rigor and thoroughness. The famous golf professional Gary Player is reported to have said, "The harder I practice, the luckier I get." The same applies to preparation for cross-examination. There's simply no substitute for hard work. Knowing the file perfectly will enable the cross-examiner to navigate between topics. Now, at the same time, don't forget that you need to be ready to conduct the cross. Being ready means that you're confident, both in preparation and yourself. While the former can be solved by working on the case, the latter requires you to try and ensure you're in control of yourself in the situation. Leading across is a high-pressure situation. I've been doing this for over 20 years and still want to conduct a cross in a very big case. My adrenaline is pumping. Therefore, it's important to take the time and ensure you're feeling like $1 million. Do whatever worked for you. It can vary from wearing your best suit, your lucky tie, or just building a routine before the hearing that makes you feel confident. Whatever it is, give it some thought and get it done. I think the three approaches in preparing for cross. In a cross, an advocate wants to accomplish a few things: obtain admission from the witness, impeach their credibility, and/or make it evident to the tribunal that the witness has not provided all the information that they have. It is important to remember this motivation when preparing the cross. The idea is not to necessarily look spectacular as a lawyer, but to get the job done. In the over 200 arbitrations I've been involved in, I've seen lawyers from across the world lead cross-examinations, QCs from the UK, lawyers from the United States, Asian civil lawyers, European lawyers, etc. They all have different styles and methods, but honestly, it's possible to break down the methods that they use to prepare in, I think, three broad categories. The first method, you write each and every question you think of asking down. You anticipate multiple answers for each question and follow up questions, and write up follow-up questions. You try and anticipate every possible permutation and list a detailed matrix of questions based on those. This method, of course, takes the longest time to prepare. In the second method, you write down the admissions you want and list up the important documents, and that's it. You don't write down any questions. All you have with you are the documents you seek to rely on and the admissions you want. This is less painstaking to prepare, but incredibly difficult to pull off. Requires both an extraordinary knowledge of the file and immense self-belief. I've seen, I think, 3 people pull this off. I had one experience where one lawyer, he had 5, he wrote down 5 admissions and wrote down 20 documents, exhibits, and that's it on one page. And that cross-examination lasted for 3 hours. So, and it was amazing. So that's one, another, the last method is how I do normally my course is a hybrid approach. You don't write down all the questions you can possibly ask, but you write down key questions on a piece of paper. On the same page, you write down the key admissions you're looking for and notes on the documents. You leave some space on the left side of the page so that you can use that to write down questions while you're conducting the examination, or or something that you think of maybe a couple hours before. Utilize all the tools you have, but be ready to adapt. The idea is that you prepare yourself to get into a flow. Even if you don't get admissions, you would have ideally impeached the credibility of the witness. So there's no correct way to prepare for a cross-examination. Each one has to find his own style, but as previously pointed out, more than the method of preparation, it is the content and quality of preparation that will distinguish a good cross from an average one.
Thank you very much. And instead of asking for volunteer to comment, I would like to move on to Ms. Joy Tan's presentation on the permissible witness preparation. So John talked about how to effectively prepare, but Joy will talk to you what you should not do or what you can do in witness preparation.
Well, indeed, Hiroyuki, and this obviously is a topic of some controversy as to what you can do and can't do in terms of preparing your witness for cross-examination. And the 3 things, again, 3 things that you need to distinguish from in dealing with this topic are, firstly, witness familiarization, right? Which is, explaining to your witness the layout of the hearing room and the likely order of events, etc., etc. Familiarization, which is uncontroversial. You're allowed to do this generally. Second is witness preparation, which is often permissible, but sort of it depends on how you do it. And third is witness coaching, where essentially you tell the witness what to say, right? And the third thing is obviously prohibited, right? So the challenge is navigating the second category, and that is by and large an ethical question of professional conduct rules of the counsel concerned. So in certain countries, including the United Kingdom, lawyers are actually prohibited under their rules of professional conduct from sort of preparing the witness in advance. That sort of applies to national court proceedings, although this may not extend in quite as much detail in international arbitration. But conversely, you've got jurisdictions like the US where extensive witness prep, including sort of full-blown rehearsals with actors, sort of, having sort of full steam ahead mock cross-examination. I mean, that's not just lawful, that's actually common practice. In Singapore, which is my home jurisdiction, the ethical position is sort of somewhere in the middle in terms of what is permissible witness preparation. We've had a local case, and our Court of Appeal set out 3 broad guidelines for what it is that you can and can't do, right? And this flows from the fundamental principle that your witness's evidence must be his or her own independent evidence. So the Court of Appeal essentially said, first, lawyers are not allowed to let themselves or anyone else supplant the witness's testimony. Second, your witness prep shouldn't be too lengthy or too repetitive. And thirdly, you're not supposed to carry out this prep in groups of witnesses in order to prevent cross-contamination of those testimonies, right? So in international arbitration, I think it's now sort of widely accepted that counsel can and do engage in witness preparation, which includes some form of rehearsal as well as practice, question and answer, as long as it doesn't amount to witness coaching, right? And we've got guideline 24 of the IBA guidelines and party representation in international arbitration that does, discuss this issue. But at the same time, different counsel may have different home jurisdictions and they may be bound by different ethical and professional rules. And, there is always some debate as to whether this does give rise to an inequality of playing field between the parties, right? And I think that continues to be an open issue. I mean, for me, the crux of good witness preparation is, really to help your witness develop confidence so that they can testify effectively, as well as, of course, truthfully. The adversarial hearing does create an unfamiliar and stressful environment, and good prep will familiarize the witness with their own case and sort of help them, strip away the unnecessary jitters so that the tribunal can properly assess credibility. I mean, you may know that your witness isn't lying, but they're just so rattled by cross-examination, that they can't, they're confused, they can't answer properly. But, that might not be so clear to the tribunal. So the crux of prep for me is to really sort of settle down the witness. It's correct, I think, to start with the witness's witness statement. And as well as sort of go through possible lines of cross-examination, including a dry run, and that is something that is done in Singapore. But of course, the temptation is to not do just one, but several rounds of sort of intensive dry run, and the case does suggest that we're not encouraged to do this. Again, there is a temptation to help the witness prepare a script. But again, this should not be done. I actually personally think a script is counterproductive, but if the witness wants to prepare one, he should prepare it himself. And I don't know if anyone else has any other tips for preparing their witness.
Anyone to volunteer?
There's something else that you need to think about if the witness is, oh, sorry, Nick, I did not know you were holding it. You had. If you are preparing the witness who needs to speak through translation, there's actually a prep that you need to do in order for the witness to make himself or herself clear through translated sentences. So speak shortly in short sentences, wait for the translator to finish. And that is something that people usually do not do. And if they do, they rather do it in a friendly environment and not being crossed. So I think that's something that you need to do.
Thank you. Nicholas, I asked you for a short comment followed by your presentation on the very basic issue of the purpose of cross-examination.
Thank you very much. The only comment I was going to make was to underscore Joy's final point about a script being counterproductive, even putting aside the ethical questions, to note that there is an ethical debate about the extent of appropriate witness preparation, but that to one side, too much preparation produces witnesses who are plastic and inauthentic, and therefore the whole exercise becomes counterproductive. So I think even from the effectiveness angle, we need to be very cautious about how much witness prep we do. Let me come then on to your question about the purpose of cross-examination. Many of you will have heard the oft-quoted line from one of the Wigmore evidence treatises in the US, in which he says that cross-examination is the greatest legal engine ever invented for the discovery of the truth. A fairly grand purpose for cross-examination. I want to offer some relatively more modest purposes to think about as you prepare cross-examinations. First, at a rather more abstract or institutional or macro level, and then some more specific to particular cases. At the macro level, it seems to me there's two purposes that we ought to think about. One is a disciplining purpose. What do I mean by that? In the context of international arbitration, by and large, there is no direct oral testimony from witnesses. Their direct testimony is written by way of witness statements, and they're typically simply invited to confirm the witness statement orally at the hearing, and then the hearing proceeds directly to cross-examination. So it seems to me that a central purpose of cross-examination is disciplining what the witness puts in her or his witness statement. Knowing that there is a cross-examination, potentially over many days, at the end of the process, I think is a critically important objective. Second, there is a basic point about fairness. A case has been brought. The party deserves to be heard, at least in the international arbitration context. The vehicle through which they are heard is cross-examination. Similarly, if evidence is to be dismissed, it must first be heard as a general proposition, without today delving into the details of the rule in Brown and Dunn and its applicability in international arbitration. At least witnesses should be heard before their evidence is accepted or rejected. So there's a basic fairness point. Coming to the rather more granular, what else? Well, you want to get at the truth, but that is a background point. You might want to achieve some relatively more modest goals. You want to point out inconsistencies in the witness's evidence, inconsistencies between her written evidence in the witness statement and what she said in contemporaneous documents. That is a very powerful thing to achieve in cross-examination. You said this in the email at the time, you say a different thing in your witness statement. In short, you may want to problematize the narrative that is put against you. A story has been built against you. You want to find a way to challenge that story, problematize it, make it altogether more complex. The final thing I would say is you may want to use cross-examination to challenge the witness's credibility. You need to be ever so careful doing so, but you may want to do that. You may want to suggest that he has lied once and therefore he is lying again. It's a difficult thing to achieve, but it may be a purpose of cross-examination in a particular case with a particular witness. With that, I will pause.
Thank you very much. Maybe I should add that it's not a good idea to try to cover every and all issues in the witness's written statement in the chronological order, in the order of the written statement. That is a very bad idea. You need to have some focus. Okay, let's move on to the next topic by Seon Kim. It's tips for crossing witnesses with interpretation, which you may encounter oftentimes. Seon, please.
Yes,
and
thank you.
let me ask you to make it shorter, 3 minutes perhaps. Thank you.
Okay. Now, 3 minutes, 3, 3, 3, and 3 rules for cross-examination questions that you already know. You have to do closed questions, which are yes/no questions, and you have to use short questions, maybe 8 words or less, and then 1 idea per question. And the whole purpose of these rules is to make your questions clear. Now, these rules are more important when you are doing a cross-examination with interpretation. It is also less difficult when the language order of the 2 languages are the same, but in translations where the language order is different, it's even more complex. And Japanese, Koreans are the languages where the sequence of the language order is so different that you have to think about a very, very short sentence that cannot be interpreted wrongly, even by a less skilled interpreter, because you don't want to fight with the witness because of wrongly delivered sentences. So you want the witness to understand what you're asking for, not what has been interpreted. So in order to create less problems, you have to use real short sentences. Also, in translated examination, you cannot jump in the middle of an answer and cut the witness down there, because you have to wait until the translation is done. So if you pose these short and close questions, you will be able to cut off the witness after his first sentence, because you know that you only need a yes or no answer. So if he goes on to the second sentence, that is already too much of an answer. So try to ask, and one other tip is try not to ask questions that are in negative, because yes and no can be different in different languages. I'll give you an example. So the question is, you did not go to school. In English, if you did not go to school, the answer would be no, because that means you did not go to school. In Korean or Japanese, if you ask, you did not go to school. If you did not go to school, then the answer is yes, because you're answering to the whole question. So do not ask a negative question, because the first yes or no comes out differently. And unless you have a real skilled interpreter who would be able to do it correctly, you get a wrong answer on the transcript. So to end in 3 minutes, 3 things to remember in preparing cross-through translation. First, get the best translator available. That is the most important thing. Second, agree on a rule for correcting the interpretation. Agree on who on each side will be making objections when a wrong interpretation is made. Otherwise, you will end up in a mess of objections and others. And if you are going to be questioning the witness, try to have that done by some other person, so that you will be able to concentrate on your questions themselves. Third, stick to the 3 rules for cross-examination questions. Thank you.
Thank you very much. And next, we have the last topic for Darius. That is the leading question. Could you make it very briefly in 3 minutes?
Yes, I can. And leading questions are simply questions that suggest the answer, right? And there are 2 tips, that some of which have already been mentioned. And the first is, when you draft a question that starts with how, what, when, why, or where, it's likely not going to be a leading question, because it's going to allow the witness to explain. So avoid using how, what, when, where, why in crafting your leading questions. The second suggestion that has been made would be, just establish 1 fact per question, right? Just 1 fact per question. So for example, an open question would be, what do you have for lunch? A leading question would be, you had McDonald's for lunch, didn't you? So that's an easy example. In the interest of time, I'm just going to pause there, because I'm conscious we've also got some questions in the Q&A box.
Anyone to volunteer? If not, why don't we move on to the Q&A sessions? And I have a question. Are there any benefits you find to have the hearings in virtual settings? So not on the cons, but the pros. They want to know. Anyone to volunteer? Maybe setting aside the effectiveness and perhaps we, yeah.
Yeah,
Sayan,
well,
please.
it is separate and apart from, as Hiroki said, the effectiveness or the advocacy skills. The best benefit that we have at the moment is reducing delay. So you can go on with the virtual hearings and have your case done. So for cases where actually the hearing is not really that important, it's getting it done and getting your answer, getting your award faster is more important. And also virtual hearings, I think, because of the ease of people getting together, can be used frequently in order to get some issues resolved. Instead of having a full hearing, you can have one day hearing like a CMC, which used to be like CMC, to get some of the issues resolved before in-person or virtual hearings of the witnesses are heard.
Yeah, if I could add a slightly different point. I have the sense that the virtual hearing actually allows the witnesses possibly a better experience. I mean, just speaking from the witness perspective, right? I'd spoken earlier about how sort of stressful a normal arbitral hearing is on the witness. It's very confrontational in cross-examination. You know, the cross-examiner can sort of get up close to the witness and engage in you know, a bit of well, badgering occasionally, right? And the virtual hearing would allow the witnesses to sort of step away a little bit and be not so nervous. And you know, that might result in the tribunal being able to assess credibility a bit better. Just from the witness perspective. Of course, as cross-examiner, you'd like to be able to get up close and personal with the witness. But from the perspective of arriving at the, you know, a better decision, sometimes, possibly, on credibility, I think that might be a benefit of having the virtual hearing.
You know, that's exactly what I thought of as well.
Yeah.
You know, if you have a vulnerable witness, and this may be a cynical answer, but you know, there's less, I think, opportunity for a good cross-examiner to attack a witness through a virtual hearing. So if you have vulnerable witnesses, I think there's benefit, as Joy said. The witness will be much calmer, I think, and there's various different things, tools that you can prepare for. So,
Thank you. One last question. Can you recommend books to help improve our skills in advocacy? And I know that there are many traditional books on the cross-examination, like Wellman on cross-examination, which many of the young Japanese litigators are recommended to read. I read it maybe 35 years ago. But I'm wondering if there is any good book on advocacy. Nicholas, you have any idea?
I think Doak Bishop's book, which I think is called The Art of Advocacy in International Arbitration, in any event, it has art in the title, is a very good book. It's relatively slender. It's focused on arbitration, draws on his experience. I think it's a very helpful reference guide.
Yeah. Youn, in Korea, people refers to what kind of books on advocacy?
I don't think I ever read a book on advocacy before, so I'm not sure, because our court practice is does not involve that much oral advocacy. It does involve cross-examination before the court, but it doesn't involve that much advocacy. So I'm not sure whether there's a Korean book on international on even court proceedings advocacy.
Yeah, I think probably the best way to learn is to see how the experienced counsel will behave. I was happy enough to see Gary Bourne in several big cases, and that was a very helpful and impressive experience. And I wish that the participants today will also have such kind of personal experiences in learning a lot from your co-counsel or senior colleagues. And now time is up, and I thank all the panelists to give us a very thoughtful presentation. Thank you very much.